Opsioni como ochana iso ha ejit politics awani. Podcast of September me kusimiki headlines na Ǎnĝr na iribi eksumoni di dunia hubrak simunia besok se yang ko e amanyu simuni na unia ye Abdul Hanan Wahab ye Bafastok siu ye ni case no unia okopie mu court na lawyer Odame enkano a unia ye jibusa ne se na lawyer we na wase ne ho fa no oyare enti amba na court ehye ne se ida se obepe lawyer kofro anase ombepe na omu atwa asem so onuya be so se mu ransim nim na enhwe ne ko ne de ba age politics up.
For the embattled former National Signals Bureau boss Kwabena Edu-Boahen. Kweku Asante is here with me. You have a copy of that warrant. What does it say?
Yeah, and that claim was made in that interview with you yesterday on Top Story.
Right.
But if you look at the warrant that we've gotten under the hand of the Chief Justice, it reads, and I want to quote, it says, "By virtue of the powers conferred upon me, I hereby authorize you to sit as an additional High Court judge at the Specialized Court 1 Law Court Complex Accra during the 2026 legal vacation and conduct hearings. By copy of this letter, the Deputy Judicial Secretary, Court Manager, Law Court Complex is accordingly notified." So it is general in terms of the practice, and I'm sure if you go to Justice Achibonga's court, he's hearing more cases than the specific of the oral cases that have become the subject of the controversy. It is a very open-ended warrant that does not limit him specifically, as Samuel Atachi had claimed. It talked about hearing cases during the 2026 legal vacation and conduct hearings. It does not limit it to Kwabena Edu-Boahen's case or any other oral case for that matter.
Well, Samuel Atachi has also insisted that he informed the judge, Francis Achibonga, that he would not be able to appear before the court to represent his client. But the deputy AG keeps insisting that that has never happened. What do you know?
Yeah, it would appear that perhaps that notice has not come to the attention of the judge because, I mean, again, as Atachi explains to you, usually you cannot write directly to the judge, you write to the registrar. But this specific letter went to the Chief Justice, it was copied to the Attorney General's Department and to the registry. So either the letter has not gone to the registry or it has gone to the registry and the registrar is yet to draw the attention of the judge and put it on record. But also there are different other avenues that this may have gone to the judge. Kwabena Edu-Boahen was in court the last time and he could have intimated the specifics, except that he said that he was not aware whether Samuel Atachi was in the jurisdiction or not. But yes, if you listen to what do we call it, Samuel Atachi, he's clear that in his petition to the Chief Justice, he's copied the Attorney General and he's copying the court registry, and he expected that the letter would have gotten to the presiding judge.
Well, thank you very much. That's Kweku Asante there, giving us the details of that warrant that we have secured here at Joy News. And if you're just joining us, this is the Pulse here in Joy News. We're also live on various numerous social media platforms as well. Well, the first accused person and former chief executive officer of the National Buffer Stock Company, Abdul Hanan, told the specialized division of the Accra High Court that his lawyer, Godfrey Odame, could not appear before the court due to ill health. Odame had last week petitioned Chief Justice Bafo-Boni asking him to revoke his warrant, directing that the trial of his client should proceed during the legal vacation. He described the directive as unprecedented and indicated that he would not appear for the trial until the end of the legal vacation. However, in a dramatic twist today, his client, Abdul Hanan, told the court that his lawyer is currently on admission and is in and out of the hospital, explaining his absence. Let's engage Fatau Bayaga, who was in court for us this morning and is joining me in the studio right now. Fatau, Godfrey Odame had earlier indicated that he wouldn't be able to appear before the court, and it was confirmed by his client, Abdul Wahab, today. What else happened in court? Walk us through.
Yes, so Ken, in court today, the only person who was missing was Godfrey Odame, lead counsel for Hanan Abdul Wahab in this particular case. In fact, today was meant for the continuation of the trial with the first prosecution witness seated in court for that to happen. But after the Deputy Attorney General introduced himself and the other lawyers that he came with, the judge, Francis Achibonga, then asked the first accused and second accused, I'm talking about Hanan and his wife, where their legal representatives were. And then Hanan in the doc basically said that his lead counsel, Godfred Odame, is currently indisposed. He said he is unwell, and that's the reason he couldn't appear before the court. And in fact, in that particular statement, he prayed to the courts that they would need more time, so the judge should adjourn the case, he prayed for a long adjournment so that they would return to court for this particular proceedings to continue.
Well, the Attorney General was represented by his deputy, Dr. Ťr0ublě. He holds a different view. What did he say?
Absolutely, Ken. So for him, he said that he doesn't believe that Godfred Odame is unwell at the moment because before this today, he had made it clear that he was not going to come to court because of the legal vacation. And he explained that he had personal commitments, and that's the reason he wouldn't come to court. So the Deputy Attorney General, Justice Ťr0ublě, basically said that he doesn't believe that story and told the court to dismiss it and allow the proceedings to continue.
Fatal, don't go yet. Let's bring in Alfred Ťr0ublě. He's a former Deputy Attorney General. Welcome to the program.
Thank you very much, my brother.
Right. I'll come back to you pretty shortly, but please don't go yet. I still have Fatal Bayaga in the studio with me. Fatal, what else happened today?
So basically, the trial judge, Francis Apanga Chibonga, he then said that, the client wasn't speaking from the bar. Speaking from the bar basically means that he is not a lawyer and he wasn't represented by any, legal person. So saying that Godfred Odame is indisposed, among other things, it's difficult to believe that. But then, based on his, personal or his discretion, he would adjourn the case briefly. Briefly means that he would adjourn the case to the, on to the 17th of August, where the parties are expected in court for this proceeding to happen. And what is going to happen on Monday would be that the counsel for Hanan, they have filed an application for stay of proceedings at the Court of Appeal. So, and then they want the High Court to stay its proceedings until that particular appeal is determined. So on Monday, the judge said both parties are expected in court so that, Hanan's lawyers will explain to the court why they think that the High Court should stay its proceedings until the determination of that particular appeal.
Thank you very much, Fatal Bayaga. As I mentioned earlier, Alfred Ťr0ublě is a former Deputy Attorney General. He's joining the conversation right now. Welcome once again, Mr. Ťr0ublě. First of all, there is a big debate about whether judges should sit on cases during legal vacation. What's your take on that?
All right, thank you very much. Yeah, my take is very simple. There has been a practice prior to independence. That practice has continued up to today. And the practice has been that judges at the end of every legal year, that's July ending, go on legal vacation for the Superior High Court judges. And I think that practice must continue. However, I will agree to a proposal where it can be tweaked to the effect that judges at the Court of Appeal and the Supreme Court must equally have vacation judges to attend to urgent matters.
Right. And there are those who argue that this is not the first time that we're seeing cases like these with a legal vacation in place and then judges are sitting. So what makes this so special that we've been hearing confrontational arguments from Samuel Atachia and then also your former boss, Godfred Odame, who are both representing clients in court?
So what is the established practice? And the practice pre-independence and post-independence has been very simple. Vacation judges are supposed to attend to urgent matters, especially matters relating to the application for bail, matters relating to injunctions, matters relating to the administration of estates, electoral administration, probate, etc., etc. Vacation judges have not been hearing substantive matters, that is, taking evidence and then allowing counsel to also cross-examine witnesses. However, if a vacation judge is minded to hear substantive matters during vacations, the lawyers in the matter are always consulted, and if they have no objection, then a warrant is secured, and then the matter is heard during legal vacation. But in this particular instance, we are told that the lawyers were not involved in the decision to hear the matter during the legal vacation. I think that's where the problem is.
Well, and it does appear that Samuel Atachia and Godfrey Odame have all taken an entrenched position that they will not appear in court so far as the legal vacation is still in place. Would you advise them they do something else other than the entrenched position that they've taken? Because just yesterday, the case involving Samuel Atachia's client, the judge was explicit saying that if Samuel does not appear in court during the next hearing, the accused person will be forced to cross-examine the prosecution witness. So do you think that the lawyers should take a different approach rather than saying that they are not going to appear in court so far as the legal vacation is in place?
The lawyers have a right that we cannot take it away from them. If the lawyers are very much convinced that their rights and that of their clients are being abused, I do not think that they should sacrifice it and say, because of this, we want to just overlook it and go along with the hearing of the matter. And so if you are to give an example, if a judge says that I'm going to hear your matter 12 hours in a day, and you are a lawyer in a matter, and he tells you that if you do not show up, I'll go ahead and hear the matter 12 hours. As a lawyer, will you still be in court and hear the matter? If you have an objection, you raise it. That's the way that these judges and lawyers have also raised their objections. And so I leave that decision to them, but they are within their right to raise an objection. We are a nation of laws. We are building a society where in the future we can also be looking back to. If there's a decision now to change what we have been observing pre and post independence, there must be a basis. And so if I were counsel in the case, I would have raised the same objections because I was not consulted. There was one particular case that those of you in the media will have to look at, the Hinaku case, Page Capital. That case was conducted during our time. The judge in July realized that there was a witness who was undergoing examination, but counsel for the accused person said he could not finish within that time. The judge then invited both counsel and sought their consent if they were ready to have the matter continue in the vacation for 2 days. The lawyers agreed, and the judge subsequently wrote to the Chief Justice for a warrant to hear that substantive matter for the 2 days in the vacation. That is the established practice. Judges know this practice. Lawyers know this practice. So why the deviation now?
Right. We will delve more into this, but in another subject related to this, we've been hearing of a private citizen by name Elom Kwame Goni, who has sued the Attorney General, Dominic Ayini, and Chief Justice Paul Bafuboni. He's demanding that the Supreme Court declares the annual legal vacation unconstitutional. What's your take on that? The annual legal vacation, should it be scrapped? Do you even agree with that suit that has been filed by the private citizen?
I mean, I have read that suit. It's an interesting suit. On the face of it, it seeks to attack legal vacation in general for the Superior Court judges. But if we go deeper into the arguments made by the plaintiff, he's limiting himself to the Court of Appeal and the Supreme Court. And that's why in his rate, he has looked at CI 19 and the CI 16, but has never touched CI 47. That regulates the High Court as to how they are to conduct their business. And the vacations are also contained in the CI 47. As an earlier I said, the practice now is that Court of Appeal does not have vacation judges. Supreme Court doesn't have vacation judges. But the CJ reserves the right, as and when there's an urgent matter, to issue a warrant for Court of Appeal to sit on a specific matter as well as the Supreme Court. That has been the practice. But the suit is now saying that even they should not enjoy the vacation at all. Respectfully, I disagree on that score, but I will agree with the plaintiff to the extent that the Court of Appeal and the Supreme Court should also have vacation judges.
Well, today the case involving Wahab Hanan did not see a lawyer for that case, your former boss, Godfrey Odame, appear in court. Well, he tells the court through his client that he is unwell. But the deputy AG says he's not buying that because even before this confirmation or this information was passed to the court, Godfrey Odame made it explicitly clear that he is not going to appear in court during the legal vacation. I'm wondering, have you heard from your former boss? How is he? Is he fine? What do you know?
By the grace of God, he's faring well today. But let me ask this question. The fact that the former AG, that's the Hanan, his position that he will not appear before the court to hear the matter. Are we saying that the two events are mutually exclusive? Are we saying that the two events, he's saying that he will not be able to appear? And he also stating that, or his client saying that he's not been well, are they mutually exclusive? It is possible for the former AG to say, yes, I will not appear because of this protest. But that does not mean that he cannot force. And so I disagree with the deputy AG when he says that because of the prior statement, it is not true that, or it is not possible that the former AG has not been well. I disagree with him. After all, I know that the practice is as the accused person. He may want to have the medical report to indicate that indeed the former AG is indisposed. That one I have no qualms with it.
Okay, well, let's go back to the case where Samuel Atachia is serving as the lead counsel. Now, the court has given the next hearing date as the 17th of August 2026 for the court to reconvene, and Samuel Atachia, as I mentioned earlier, is not budging. Do you think that if Samuel Atachia eventually fails to appear in court during the next hearing, that could lead to an unfair trial?
Mr. Atachia is a seasoned legal practitioner. He knows his staff, and he knows what he wants to do at any particular event. I don't know what he may want to do by the 17th of this month. But if his client goes to the court on the 17th without him, and depending on what his client will say, the court may want to oblige him. Because these matters that we are talking about are very serious matters. If, for example, his client tells the court that my lawyer says he's not coming, and for that matter, I want to engage the service of a new lawyer, can the court go on and hear the matter? And if he's to engage a new lawyer, how long would that new lawyer take to go through the proceedings before he can continue with the hearing of the matter? That's why I would rather advise that the court should also hasten slowly, give the accused person every latitude. After all, Ghana is not collapsing today. Ghana will continue to be Ghana. And so even if the matter is not heard within this term, it doesn't mean that the accused person will not be in court for his fate to be determined by the court.
Well, we've been hearing from a lot of people within the legal fraternity. Key amongst them is the Ghana Bar Association, who have actually called on the judiciary to halt the conduct of substantive trials during the break. What's your position on that? Do you agree with them?
I agree with the GBA 100%. The judiciary is aware that the position of the GBA is the correct position. I mean, judges cannot talk, but they know that that is the position of the judiciary when it comes to even hearing of substantive matters in the vacation. And so the GBA has sought to remind the Chief Justice that he has the power to grant warrants for hearing of substantive matters in the vacation. But in exercising that power, he should be reminded and cast mind back to the established practice. For all you know, if the lawyers had been engaged and reasons advanced, perhaps we wouldn't get to where we are today. Because as I told you, in the Aku case, the lawyers were engaged and they realized that fine, they should come back in August 2 days to finish the cross-examination because the witness had been in the box and they needed to end his cross-examination. But now we do not even know the reasons why a court of appeal judge, let's listen to me carefully, a court of appeal judge is being made to sit as a vacation judge. The other judge is a high court judge and still has, say, high court judge will sit as a vacation judge. But
Right.
what business does a court of appeal judge have in sitting as an additional high court judge? That's also one issue we should be interrogated.
Right. Okay, don't go yet. I'll come back to you. But there's one person who actually disagrees with your opinion and that of the Ghana Bar Association. That's the Majority Chief Whip, Roxanne Nelson Dafia-McBaugh. He spoke on PM Express last night. Let's listen to him.
He's the one complaining. It's not a law firm that is complaining. So first of all, GB has no business in dealing with this matter because the law firm...
We in some ahodoɔ timi ɛkɔ so ɛwɔ channel no so ma me na wɔsɛ ɔgye mmerɛ da sɛ so what in there don't be a ever sign issue